everyone. This is Megan Lestino with National Council for Adoption. I am here today with my friend McLean Layton of Equality for Adopted Children, and we have with us also Christine Porch. I'm going to let them both introduce themselves and tell us a little bit more about them, and then we're all going to talk a lot more about this new change in fee to the USCIS Certificate of Citizenship. And McLean and Christine are going to share their super expertise with us so that we can do our best to get citizenship for lots of kids before that deadline changes and costs increase for families. So McLean, why don't you kick off and tell us a little more about yourself?
Great. Well, as Megan said, I'm McLean Layton. I'm with Equality for Adopted Children. And actually, I was very involved in the original drafting of the Child Citizenship Act, which resulted in getting citizenship for our foreign adopted children of American citizens. So I'm very, I was going to say excited to share with you about this issue, but it's really a great concern to me that you make sure that all our foreign adopted children are documented as citizens within the United States. And so, anyway, when we learned of this fee increase, it's increasing from $550, which is currently the fee for getting a certificate of citizenship. All adopted children don't necessarily need to apply for that because many of them will have received this already. But for those of you who have not received it, it's currently $550, and on December 23rd, it is going up to $1,170. And so I think now is a great time to get your paperwork in and file the N600 form, which we're going to talk about more later. But before we get into more details, I wanted Christine to introduce herself.
So hi, everybody. I'm Christine Porch. I'm a private immigration practitioner, and I'm just outside of Roanoke, Virginia. And McLean and I have worked together for a number of years on a number of different projects. And so it's not unusual for the two of us to be ganging up to encourage all of you to make sure that you get your N600s filed timely before the fee increase. We're going to cover some details about when you file, how you file, and all of those things. But I think first and foremost, McLean wanted to kind of give you some background so that you understand which individuals need to file and who really doesn't, so that we're very clear about the basics before we kind of move on to some of the more specific details.
Great, thanks, Christine. So if you want to put up the slide that we have prepared.
Absolutely. There we go.
Just that one. Great. Well, thank you. So there, when the Child Citizenship Act passed in October of 2000, it became effective on February 27th, 2001. And on that date, we estimate over 150,000 foreign-born adopted children of American citizens received their citizenship. Now, they received it through operation of law, meaning there was no document that was handed to them. Nothing was given to them at that time. It just was boom, the law passed, it became effective, and they became citizens. It took USCIS about 3 years to about 2003 to start automatically generating certificates of citizenship for these foreign adopted children of American citizens. And they only did it prospectively. They did not go back and issue them for adoptees who were citizens now under the law, but who had entered the U.S. Prior to the implementation of the law, and also prior to 2003, when they finally got all the regulations and everything in place to automatically generate a certificate of citizenship for foreign adopted children. But there's two types of visas that foreign adopted children enter the United States on. And depending on which type of visa your child entered determines when citizenship attaches. So if you have your child's original passport from their country of origin, in the back of it will be a visa stamp. And on that visa stamp, it will either say IR3 or IR4 for non-Hague countries. And then for Hague countries, it's IH3 or IH4. But we are focusing on non-Hague countries today, which is primarily where children were coming from initially. So the IR3 visa means that both adoptive parents, if there were two, traveled to the country of origin and met their child during the adoption process. And therefore, and it means that that child was fully and finally adopted in the country of origin. It was not a legal guardianship, it was a full and final adoption. So they were given an IR3 visa, and under the Child Citizenship Act, when they arrive in the United States, citizenship automatically attaches. And after 2003, the certificate of citizenship was automatically generated and mailed to that child. So that is what happens when you receive an IR3 visa. So if on the back of your child's passport it says an IR4 visa, those were given to two categories of foreign-born children. It was given to a foreign-born child with a full and final adoption, where only one of their adoptive parents had traveled and met the child during the adoption process. That law has changed since then, but it doesn't matter that it's changed. Just look in the back of the passport and see if it's an IR4. So another reason if they would be given an IR4 is if the adoptive parents only had legal guardianship. For example, Uganda issues legal guardianship. South Korea used to issue legal guardianship. And so the adoptive parents would get legal guardianship of the child and bring them to the United States. And if they entered on an IR4, it automatically generated a green card, or they were considered legal permanent resident aliens. And so this green card was generated because until there was a full and final adoption, where both parents had met the child, they were not citizens yet. This was the State Department's interpretation of the Child Citizenship Act. And so therefore, before citizenship would attach, you would have to take your child and adopt or readopt the child in state court. As soon as that adoption was final, citizenship attached to that child. So again, there was no proof, there's no document that it generated, but your child is a citizen of the United States, even though they have no documentation to prove it. And so unless you've got, unlike an IR3, where an IR3 foreign-born child enters the country and a certificate of citizenship is generated, an IR4 family, a child's family would have to apply for a certificate of citizenship. And that is using the form N600. So bottom line is our foreign-born adopted children under the Child Citizenship Act of 2000, who were 18 or younger at the time that bill passed, are 99% of them are citizens. The only reason they would not be a citizen at this point is if they came in on an IR4 visa and no further steps were taken to adopt in state court. Christine, do you have anything to add to that?
I don't.
Okay, thanks for that, McLean. So I've gotten some questions about what the difference between a certificate of citizenship and a passport is. Christine, could you tell us a little bit more about why a passport isn't enough and what exactly a certificate of citizenship is?
Sure. Well, I can certainly distinguish between the two. If you don't mind flipping to the next slide as well, I'd be grateful. So in essence, a certificate of citizenship is from USCIS. And so it's a document that doesn't have an expiration date. And we should be very clear to say it isn't that the passport isn't enough, and it isn't that the certificate of citizenship is the end all be all, but it is in some ways more effective proof. And so really what we're talking about when we're distinguishing between these two things is the best proof of one's citizenship status. And so in certain circumstances, there are certainly parents who have elected to get their child's passport and maybe never gotten a certificate of citizenship. And only when that child is in high school, engaged in sports or in other kinds of events, has it triggered any inquiry like, well, we're accustomed to seeing for FAFSA purposes a particular document. And so it's always helpful, in my opinion, to have both. It is much faster in some ways to get the passport immediately upon entry to the U.S. And so we in general just want to make the point that the certificate of citizenship is the best proof of citizenship status. The U.S. Citizenship and Immigration Service is in essence issuing that certificate to say this individual has met the requirements under the CCA. In the same way, the Department of State, when they issue the passport, is in essence confirming with USCIS that those requirements were met. So it isn't that one is secondary proof and one is primary, but rather that one doesn't have some of the difficulties that the other does when it comes to practical use. So in terms of practical effectiveness, we want to see folks, especially before this big fee increase, get certificates of citizenship where applicable. And I think it's just, frankly, it's one more peace of mind that you have about what documentation exists for a child, or perhaps now an adult who may need to document their status in the future.
And I would just add to that I had run into a situation with my adopted children where I don't remember what year it was, but they had their US passports, but they all expired because as minors under the age of 16, the passport expires every 5 years. And so that's another good reason to have a certificate of citizenship, because it never expires. But my 3 adopted children's passports expired, and it was at a time when there was a huge backlog on getting new passports issued because they had just started requiring passports for Mexico and Canada. So it was a time frame in which, because you have to relinquish your original passports in order to get your new one, it was a time in which I had no proof of citizenship in my possession. Now, it didn't mean that my children were any less a citizen at that time, but I just had if I had been asked for proof of their citizenship, I would have had no proof while I was waiting for their new passport to arrive.
Yeah, and I think, not to interrupt you, McLean, but I think it's really critical to distinguish between a status, right, a legal status, and the recognition of that status. So the lawful status doesn't change, but the recognition of that status, the evidence of that status, is what we're talking about here. So we don't want to create a situation where folks think that somehow their children's status is precarious or unfounded or in question if they don't have these documents. But in essence, there is a real practical need, I think, for these documents to be procured as quickly as possible and to be maintained in their current, to maintained as current.
Great, thanks. So one other question I got recently, and maybe you can address this, Christine, is what is the difference between a certificate of citizenship and a certificate of naturalization?
So a certificate of naturalization is a certificate that is based on the fact that you've completed the requirements for naturalization. So in essence, if you are a naturalized U.S. citizen, you procured your citizenship not through automatic acquisition at entry to the U.S. as a lawful permanent resident and an adopted child, or through one of the other methods, but rather you have naturalized, you have satisfied the residency requirements, you've met a good moral character test, you have demonstrated that over time, you not only have you taken the particular oath, but you've demonstrated that over time, you've maintained the kind of behavior and disposition that we want in someone who is being tested for U.S. citizenship. So that's the main difference. Is in the cases we're talking about with adopted children, this is the status of citizen is automatically acquired. It is not something they are tested. They do not have to go through the rubric of a civics test, but instead are granted this status secondary to the relationship that they have with their U.S. citizen adopted parents, and given the other requirements in the CCA and the Child Citizenship Act.
Okay, great. That makes a ton of sense. So certificate of citizenship is always the answer in the case of adoption.
Mhm.
Another question I've heard recently is about deportation. Can
Mhm.
adopted children or adults ever be deported? And
So
what does it do with the Child Citizenship Act, I guess?
yeah, so remember we were talking about a status and hearing in an individual based on them having met certain criteria, as opposed to naturalization. Once one is naturalized and once one becomes a citizen, whichever path to citizenship one takes, in order to have that naturalization stripped, there is typically a denaturalization process that has to take place. So once you attain it, you do not lose it except through a process that the government has to afford you, that affords you a portion of due process that is appropriate. Now, in the case of children, that status is acquired immediately upon entry. So even if you do not yet have the proof of that status is still there. So in deportation proceedings, we often see, I shouldn't say often, we sometimes see that the fact that one is a U.S. citizen is used as a defense, and more specifically, it is used to demonstrate that the government cannot carry its burden on deportation. So, and now in the way that we now talk about immigration removal proceedings is just another fancy word for deportation. It's due to a statutory change. So if you're in removal proceedings, if let's say that a child commits a crime, that a U.S. citizen, or I should say an adopted child who's now an adult, commits a crime, whether that individual is deportable depends on whether they are already a citizen. And in this case, many of these children, if they qualify under the CCA, and most of the ones we're talking about in this particular webcast do, then we are in essence saying very clearly you cannot be deported unless you are denaturalized. And denaturalization is a different standard, and that's not something that I think anyone that's listening to this webcast needs to be fearful of. Certainly you can research it more if you'd like, but it's not something that's common, and it is something that carries an enormous burden on the government to demonstrate that citizenship was in some way procured wrongfully.
Okay, got it. So just to make sure I get that, it's pretty rare that a child who was adopted could be deported because they've already got citizenship, right?
Well, yeah, and to say it differently, it's rare that a child who qualifies under the CCA is going to be deported because they already have the status upon entry or upon the completion of the final, upon the completion of the final step, whatever that step is, and in many cases that's the final adoption here in the U.S.
Got it. Great. Thank you. So I guess the next thing we need to talk about then is, what do adoptive parents need to do to get that certificate of citizenship?
Well, you need to file an N-600, and we're going to instead of going through the form today in this webcast sort of piece by piece, I think it's probably easier and frankly allows us to cover some of the most commonly raised issues with a frequently asked questions document that we're going to, I think, be posting currently with this webcast, correct?
Right. Yep. We'll put it all up together.
And so certainly if there are questions beyond this, then there are lots of folks who are available to answer those questions. There's lots of resources through the NCFA and other organizations, but I do want to make one very, very clear point that in an N-600 is the kind of document that can be filed on one's own. I think that there's lots of folks who say who feel very strongly that you need an immigration attorney to do every single thing that there is within immigration law. In this particular context, I think you hire an immigration lawyer for one of two reasons: because you have some concern about your child's underlying eligibility, which in most of these cases just doesn't exist, or secondarily because you want the benefit of that experience. And in this particular case, I don't think there's enough time before the fee hike for most immigration attorneys to field a lot of these calls. So certainly you're welcome to use the facts however your organization sees fit, but I think it's helpful to get that information out there so that folks feel a high level of autonomy and ability to do this on their own.
Yeah, great. Well, that's really comforting to hear, because I know I've gotten questions from a lot of families about who can do this, how do I do this, what do I need to do this? And those FAQs Christine has given us are really detailed and will help you through any questions you could have. And I actually know several adoptive parents who have done this confidently and successfully on their own. So with Christine's help, I'm sure you are all going to rock that form. I think that is all we had to cover today. Ladies, do you have anything else to add before we wrap up?
Well, I would just reiterate the reassurances that Christine gave, that our children who are foreign-born that we have adopted and brought legally to this country do not need to be afraid about being deported. 99.9% of them probably have citizenship automatically under the Child Citizenship Act. In fact, I almost want to say 100%. Only children who would not automatically have it is if their adoptive parents had failed to readopt them in their state court if they came on an IR4 visa. Again, you do not need to readopt for citizenship reasons anyway in a state court if your child came on an IR3. So, but it is critically important if they enter this country on an IR4 visa that you do get to court and readopt them here or adopt them for the first time here in the U.S. And again, we recommend highly that you get a certificate of citizenship, which requires you to apply for it, file a form called an N, as in Nancy, N600. And as Christine said, it doesn't take any particular legal expertise to fill out the form and collect the documents and send them in. So the document that she and her law firm have prepared to answer questions on how to fill out the form is extremely valuable and helpful. And I just recommend that you take advantage of this window of opportunity between now and December 23rd to get that filing in, so you can pay $550 instead of $1,170.
Absolutely. Christine, anything else before we say goodbye?
Nothing else. It's just a form, folks. So, as I was saying to somebody earlier today, immigration attorneys aren't hired, to fill out a form. We're hired for our expertise. So feel some comfort in that and know that in essence, this is really something that frankly just should be one of those extra things that you kind of tuck under your pillow at night and gives you some sense of security and certainly, some sense of evidence and proof of this very long journey you've taken for your family. So enjoy this little tiny window you have and be certain to take advantage of it.
Great. Well, thank you both for your time and your expertise today. As always, if you have any questions, you're welcome to give us a call here at National Council for Adoption, or send me an email personally. You can find all of our contact information on our website at adoptioncouncil.org. Thank you.
Bye, guys.